Welcome back to the Litigation Psychology Podcast. Dr. Bill Kanasky. This is part 2 with attorney Larry Schnapf and Jefferson Morley discussing the JFK Records Act, their lawsuit, where we're at now. Part 1 was just absolutely phenomenal and fascinating. And we're going to jump back into that. I want to jump into the weeds here a little bit, Jeff, with the latest document release, which turns out to be another nothing burger for the most part. You know, we get all this news. Oh, there's another, release of documents, and then 2 weeks later, it's like, yeah, same old. But there was one memo in there, which I found very interesting, which I'd like you to comment on, the Schlesinger memo, which I read the whole thing yesterday, and pretty much, this is a memo that pretty much this guy writes this very detailed memo, essentially saying the CIA needs to be reorganized. They got too much autonomy. They're not being monitored. And then there was a pretty good, this is right after the Bay of Pigs, right? And which was a complete shit show. And then does a pretty interesting compare and contrast of how the CIA is organized and run versus how MI6 is, and the whole, the contrast of structure, power, accountability. Can you educate our audience, particularly our younger attorneys, particularly who the CIA was in the 50s and 60s, and why this memo? Because this is a powerful memo, correct?
Yeah, so the memo you're talking about, it was written by Arthur Schlesinger, who was a professor of American history at Harvard, had an intelligence background himself, had served in the Office of Strategic Services during World War II. So was, familiar with the structure of an intelligence agency and how it worked. And he was an advisor to JFK. And so after the Bay of Pigs happens, the Bay of Pigs is the CIA presents President Kennedy with this plan. We're going to overthrow Fidel Castro in Cuba. Don't worry about it. And then the whole thing goes south. It was a completely ridiculous plan. And Kennedy had said, well, go ahead, but we're not going to have US troops. We're not going to use US air support. You guys have to do it on their own. And when the whole thing went south, Kennedy said, I told you. Yeah. And the men at the Bay of Pigs felt betrayed by the president, and there was a lot of bad feeling. Kennedy felt he'd been set up. He'd been handed a bad plan. He'd been told it was a good plan, and he could see that it wasn't. He felt like he'd been a fool to take the word of the CIA. So, at that point, that was the most humiliating experience of the CIA in its 14 years of existence. It had come into existence in 1947 as the successor to the Office of Strategic Services. The OSS was a wartime intelligence agency. The CIA became a peacetime intelligence agency. And in the 50s, they were the good guys. If they overthrew a government, well, that was, we were on the right side. The Soviet Union was bad. The CIA was, was very glamorous and respectable among liberals and conservatives. The Bay of Pigs was like, wait a second. It was like a humiliating defeat. Kennedy was like, why did I go along with this? And so Schlesinger steps in and he analyzes the problem for the president. And the problem, as Schlesinger sees it, is that the CIA is basically a policy-making organization. The State Department is like blindsided, preempted, made to look bad. And it's the contradiction that can't be supported anymore, according to Schlesinger. And maybe we need to reorganize the CIA. Kennedy himself is thinking this. He told somebody, he was venting, but he said, I'd like to shatter the CIA into 1,000 pieces and scatter it to the winds. He didn't do that, but he was alienated, and likewise, people at the agency were very alienated with him. So it's a real crisis in the point of the CIA. Schlesinger steps in and says we should reorganize it. Well, what do we care about it today? Well, that document was up for declassification. Okay, now. It's not a CIA document. Arthur Schlesinger wasn't a CIA officer, so it doesn't have the names of living informants or operations or anything. It may refer to operations, but there's no living informants in there. The document wasn't classified when it was created. It was happened 2 years before the assassination. So, you know, it was supposed to be declassified. And that was one of the documents that we had identified in our lawsuit. This is a test case for Biden. So we go and look at it. And you know what they did, Bill? There's about a page and a half of a solid block, a whole block of the memo is declassified, probably 300-400 words. They declassified one sentence.
Wow.
And the rest of it is still secret. 60 years later. And so, you know, what that tells me is the alienation of the CIA and the Kennedy's White House is still a sensitive issue 60 years later, and it's related to the assassination. That's what the CIA is telling us very clearly with their secrecy measures. This is too sensitive. We don't want to talk about this right now because the alienation of the White House and the CIA is a factor, is somehow related to the assassination. That very information that is contained in the memo is embarrassing to the CIA, and that's why they're keeping it off the record. It has nothing to do with national security.
That's absolutely incredible and disappointing. I mean, it's funny, you know, the topic of classified documents has been pretty popular lately in the media. We'll probably get the contents of Hunter Biden's laptop before we get the records you're looking for, unfortunately.
Maybe not, Bill. Maybe here's the problem. If you can't declassify 60-year-old records, right? How are you going to declassify records from 4 years ago or 8 years ago, right? I mean, it may be 60. Right. The way this is going, there may be 60 years from now, they'll be talking about Hunter Biden's.
Yeah, and are the agencies involved in these controversies today, right? Are they trustworthy? You know, and by its behavior, the CIA and the FBI, by demanding ridiculous and suspicious secrecy 60 years after the fact, they open themselves up to suspicion and they invite it. And you know what we can tell? They don't care. They don't care if the public suspects them on this. They'd rather have the power to keep the information secret. And you know, that's why this matters today. You know, our political system is locked in gridlock over fights over, you know, should this information be classified? Was it handled properly and all of that? And the agencies at the heart of the struggle, the unelected agencies at the heart of the struggle, behave in an untrustworthy manner. You know, the whole thing is completely corrosive to, you know, actually running a republic, a government. You know, it's very, very dysfunctional. And at the heart of it is this secrecy. And at the heart of the whole secrecy issue is this very small but very important issue of secrecy around JFK records. It's the symbol of the dysfunction that we're seeing at the top of the political system now.
The people, so you have people that work for these agencies, their job is to decide if records are to be declassified or not, right? This is their day-to-day job.
Yeah.
And if you're working in that position, you're going to be conservative, I don't mean by politically, you're going to be cautious about releasing records. And you have people in your agency that are going to be pressuring you not to release them. This is an opportunity to rethink. And Jeff and I feel, you know, we were too young for the church committee time. This is a unique moment in American history when we're reevaluating the whole process of classifying records. They did that in the church committee, and there were some reforms done. But this is now an opportunity, and maybe we need to have an independent body like the ARB for all of these agencies, because as long as we have people working within the agency that are tasked with making these decisions, they're always going to come. It's just human nature.
Yeah.
Always going to come out on the side. You know, they could be completely in good faith, honest people, but that's why we had a financial crisis. And, you know, every person in that financial crisis they had a little role to play, and they were doing their role, but they were contributing to this overall problem. So it's a systemic problem in our country.
Yeah.
The JFK, as Jeff said, it's just one piece, but it's the red flashing red light.
Yeah. Now, Larry, during the break, we talked a little bit. You said, you know, hey, you know, the JFK Act is still the law. Can you talk about what the Gannon memo is, and I read it yesterday and did some research on that, and what it sounds like is a justification for not following the JFK Act on these document releases, and seems to be did not get as much attention as I thought it would, but it almost looks to almost, for lack of a better word, replace the language in the JFK Act. Who was Gannon? The memo was written right before Trump, I believe, had the opportunity to release these records in 2017. And what's the main argument there presented in the memo?
So let me first start with, you're right, the JFK Act, the obligations, the agencies have a continuing obligation under the JFK Act. After the review board went out of business, there is still an obligation to do periodic review of records. And the act remains in effect until the archivist certifies to Congress that the act's requirements have been met and satisfied. At which point in time, then the act would no longer become an active law. It would go away. And one of the counts in our complaint is we are seeking injunctive relief. And one of the requests we're making is for the court to instruct the archivist not to make this determination until such time as the court would retain jurisdiction over the matter. And they would make that, because we want to make sure that the archivist does not say, by the way, President Biden's order in December provided for another review and decision at the end of June. Like 6 months after 60 years is going to be a difference, right?
Yeah.
But let's assume for the moment that something miraculous happens, right? All of the remaining records that are in the collection are released in full. What we don't want, until the issues that we have been raised in our lawsuit are adequately addressed, we don't want the archivist then saying, okay, we're all done, this is finished. We don't want that certification to be made. Curtis Gannon was a Department of Justice attorney. When the president issues executive memorandum or executive order, the usual procedure is for the order to be reviewed by the Department of Justice to make sure that it meets all the requirements for the president to issue an order. The order is effective on the administrative agencies within the executive branch. The president cannot issue an executive order against Congress, right? So Curtis Gannon wrote a very, very good memo. Give him a lot of credit. He's a very smart lawyer, justifying a 6-month extension of a postponement for 6 months from October to April of 2018. And I can't go into it too much because it's the subject of our litigation.
Sure.
But he did seem to rewrite the statute in order to support the 6-month postponement. But in any event, the memo did not support a 3.5-year postponement. And I have not seen, and the other nonprofits who have filed Freedom of Information Act lawsuits have not seen either, any Department of Justice memo supporting the April 2018 order for 3.5 years. So the Curtis memo was used. Now, interestingly, Curtis Gannon was also the attorney who drafted the Muslim ban order.
No way.
Yes.
Oh,
yes.
Wow.
Yeah.
Go figure.
So he played a big role in that administration. Jeff, I believe he's in the Solicitor General's office now, if my recollection is correct. In any event, his memo was instrumental in given the legal support to Trump for the first 6-month memo postponement. But by its terms, and it was limited to a very specific section of the statute. It was whether Section 5G 2D authorized a temporary certification. It
Wow.
did not. It did not refer to the other Section 6, which is the one that requires clear and convincing evidence. So it was a very limited. He was asked to respond to a limited issue, and it was just for 6 months, a short-term postponement. The rationale used in that memo does not appear to apply to a 3.5-year postponement, and we have no evidence that a second memo was written. Was that the 2018 order from Trump was either reviewed by Department of Justice or that there was a memo supporting that extension.
Wow. Now, Jeff, you're on mute, so unmute yourself.
Oh, sorry about that. And in larger context, what you see is, the government's mobilizing its superior resources in defense of these extreme and suspicious secrecy demands. So you have these high-powered lawyers who, they're out to justify what the executive branch wants. They're not out to get compliance with the JFK Records Act.
Yeah.
Their posture, their basic posture is part of the problem, right? It's like, wait a second, there's a law here. You're the Justice Department. Why don't you want to see that law enforced? And it's coming from the top. The president doesn't, and the CIA want to evade the accountability structures. So the legal resources are mobilized on behalf of secrecy.
I don't think it's the National Security Council which drives at least the JFK Act. That's where the decisions are made about what's to be postponed. Well, that's where the apparatus for making decisions is located. The agencies, will contact the National Security Council. They make a recommendation to the president. And I don't see any president, look what happened over the last week. The Army recommended to Biden not to shoot down the balloon, right?
Yeah.
So they waited until the balloon crossed the country. I mean, the president is not going to go against his expert, advisors. So it's just that's the situation we're in.
Yeah, I'm going to read from this is Section 5 of the JFK Act that essentially says everything should be disclosed unless the president certifies that, quote, an identifiable harm to the military defense, intelligence operations, law enforcement, or conduct of foreign relations necessitates continued postponement of disclosure and, quote unquote, outweighs the public interest in disclosure. That's the big fight, right?
Yeah, and it goes on to say that the gravity, I believe that's the section also where it says that there's such gravity that it outweighs identifiable harm. Interestingly, again, your lawyer listeners will find this of interest. When in Biden's October 2021 memo, they didn't use the term identifiable harm. They used anticipated harm.
Oh.
But they corrected that problem in the 2022 memo. We just recently had to amend our complaint to reflect the 2022 memo as well as the 2021 memo.
Very, very interesting. Now, I'm going to wrap up at the end with kind of where your lawsuit's at and what's going to happen going forward. But let's get into some sexy stuff before we do that, because I know this is Jeff's favorite topic here, which is Mexico City. And listen, I've read all Jeff's stuff. I've watched countless YouTube videos of Jeff. And every time I read or watch something for Jeff, it's just like, wow, just wow, wow, wow. And then when I read this Win Scott book, I was like, just took my breath away. Absolutely astounding stuff in that book. It's a absolute must read on this stuff. And a lot of emphasis on Oswald, weeks before the assassination and his activity, I believe in September 1963 in Mexico City, what he was doing, how closely he was being surveilled. I mean, is just off of the charts. And again, just doesn't get enough public attention because obviously what the Warren Commission is, oh yeah, we didn't know who this lone nut, no idea who he was. Yet now we know that was very far from the case, right, Jeff?
Yeah. So in Our Man in Mexico, I tell the story of
It's amazing.
Win Scott,
Unbelievable.
the chief of the Mexico City station, who was regarded as one of the best CIA officers in the clandestine service. He had come out of the OSS. He'd become station chief in Mexico City in 1956. And usually a CIA station chief is only in a country for 3 or 4 years. And then standard procedure is to rotate them out. Win Scott was so powerful in Mexico that he was allowed to stay for 13 years.
Wow.
And the surveillance operations that were mounted by his station were considered state of the art in terms of the agency's procedures. So in Our Man in Mexico, I tell the story of what did the assassination look like through this guy's eyes, right? Yeah. I mean, I didn't have a theory. Whatever he thought was 10 times more interesting than whatever I thought. And so I tell the story, and you see in there a couple of things. One, Oswald's watched very closely from day one.
Yes.
2, the CIA lies about it to the Warren Commission.
Yep.
3, Win Scott knows that his friend Dick Helms has lied to the Warren Commission. And later, after he retires, he writes a memoir in which he says, the Warren Commission said we didn't know anything about Oswald in Mexico City. That's not true. He writes in his memoir, I was in charge. We followed him the whole way. And he tells the story, and the records back him up. Of course they had him watched. Any American who walked into a Soviet or Cuban diplomatic office was watched, contacted, or surveilled, to figure out who he was. That was the CIA's job. So they knew all about Oswald. And Win Scott knew that something was going on with this guy, and he wasn't responsible. And so Scott writes this memoir to I think to defend himself. This is around the time of Jim Garrison. There's a lot of questions about the Warren Commission, talk of reopening the investigation. And Win Scott is saying in his memoir, somebody screwed up, but it wasn't me. And Win Scott concluded that the assassination was the product of what he said was a communist conspiracy. He too rejected the Warren Commission. So wow. From the inside of the CIA, super loyal guy, super competent guy, and even he doesn't believe the official story. And who would know better than somebody who had a front row seat on the surveillance of Oswald? So with that as the backstory, and you see they're still hiding stuff about Oswald in Mexico City today. They're still hiding stuff about the surveillance techniques, about the relationship with the Mexican government. You know that this is what's most sensitive to them and what they don't want to talk about today.
And I mean, isn't because I find the Mexico City information and Oswald's behavior absolutely just ground shaking, right? To this.
So let me explain to people what happened. Oswald took a bus to Mexico City in late September 1963. He'd been living in New Orleans, and he'd been talking with his wife, Marina, about going back to the Soviet Union. They just had a second child. Marina didn't speak English, and I think they wanted her to go back with her mother, to have somebody to take care of the kids. So Oswald goes to Mexico City. He goes to the Cuban consulate, and he applies for a visa, and he says he wants to travel to Cuba and then back to the Soviet Union where he had lived, where he had met Marina. And there's some suggestion that he was looking for a way to take his wife and children back with him. So he applies, and the Cuban consulate is a locus of CIA intelligence. They've got a pulse camera on the door outside that takes a picture whenever that door opens. That day and the next day, Oswald goes through that door 3 times. So there's 6 opportunities for the CIA to photograph him. The pulse camera, it was later determined, was working that day, despite a CIA story that it wasn't. 2 CIA officers in the station later said that Win Scott had showed them a photograph, a surveillance photograph of Oswald. And they described it was taken from overhead, which is where the camera was located and all of that. No such photos ever surfaced. I think Win Scott had them, but he never shared them with anybody because obviously that kind of material was radioactive and highly classified. So Oswald the Cubans say, no, if you're going to go through the Soviet Union, you have to get the Soviet visa first. So he goes to the Soviet embassy, picks up a call, makes a call, goes in, has a meeting with the Soviet officials. They tell him, no, you have to apply for a visa in Washington. And he leaves. He calls back on the following Monday, or somebody calls back and identifies themselves as Oswald. The CIA translator says this person spoke terrible Russian, wasn't very good. Well, Oswald spoke good Russian. Everybody who knew him, he had some facility for the language. He'd lived there for a couple of years. He'd married a Russian woman who didn't speak English. He knew how to speak Russian. So that raised the question, well, was somebody impersonating Oswald there? Now, I interviewed Ann Goodpasture. She was a senior officer. Yeah. She was kind of Win Scott's right-hand man. I mean, in those days, there were no CIA female undercover officers, but Ann Goodpasture really was an undercover officer. And Win Scott gave her everything. He depended on her in a way that he depended on nobody else. She was in charge of the surveillance. So when the tapes come in of this phone call, she gets they go to the translators, and then the translators send it to her, and then she would take those documents and give them to the appropriate officer who handled, the Cuban affairs or Soviet affairs or whatever. So Ann Goodpasture told me, she was retired. I interviewed her in Dallas in 2006. She said, yeah, there was a tape of Oswald, and Win Scott had it. It was in his office safe. She said the story that the CIA told the Warren Commission was those tapes were erased before November 22nd, sometime between when it happened in early October and November 22nd. That wasn't true, Ann Goodpasture said. Whenever there was a conversation of interest, we'd make a dub off of that tape, and so we just have that conversation, which makes sense. An American walking in there was to the Cuban consulate or the Soviet embassy was a big deal. That was something you wanted to capture and make a record of. So she told me, yeah, we had a tape, and Win Scott had squirreled it away in his office safe. She said the same thing under oath to the review board. So very solid information that there was a tape of Oswald that survived the assassination. There's credible testimony that there were photographs of Oswald that survived the assassination. All of this vanishes, which points to the fact that key facts in the investigation were withheld from the start. It's indisputable. The record of what we see of what happened in Mexico City. So Oswald is frustrated. He's not going to get a visa to go to Cuba. So he goes back. He goes back to Texas, and the FBI is watching him closely. They note that he's back in Texas, and they send, by the end of the month, they send the CIA a cable about Oswald saying, we know he returned from Mexico City and he's living in the Dallas area. J. Edgar Hoover sends that report dated October 30th, 1963 to the CIA. And the CIA counterintelligence staff signs for that report on November 14th, 1963. So the top of the CIA is informed that Oswald is in Texas 8 days before the president is killed.
That is absolutely astounding.
Yeah.
I mean,
and so and we have no explanation of, why no action was taken, what was going on, what did these people think, who did they think Oswald was? We have none of that. And when you see this record, you realize we didn't really have a real investigation of who Oswald was. The CIA was able to avoid the obvious questions that the paper trail raises. And now we have extreme secrecy around that paper trail. I mean, what other conclusion are you going to reach?
Yeah, no.
It's very suspicious.
Wow. Wrapping up here in a little bit, but this is another topic that I know it's very hot for you, Jeff, and part of this Records Act issue. This all ties all together. Can you tell the audience who is George Joanides, and why is he important, and why are JFK records specific to his job and his actions and his conduct? They're very, very secret. I know you want to get your hands on them. I know you've been fighting very hard for that. This is a chapter in this story that hasn't got nearly the amount of attention that it probably should, based on this gentleman's role in this whole saga. Can you kind of go over that for our audience and what you're trying to accomplish with records related to him?
Yeah. So George Joanides was an undercover career CIA undercover officer who was assigned to the Miami station in 1962. He had grown up in New York City, moved to the Athens station. He was highly regarded, and Deputy Director Helms sent him to Miami in 1962 after the Bay of Pigs. They kind of cleaned house in Miami, brought in a whole new team. And Joanides was assigned to handle one of the groups that the CIA was most actively supporting in the fight to overthrow Castro. And that was a group called the Cuban Student Directorate. And these were Cuban students from the University of Havana and other leading schools in Cuba who were disturbed by the hard left turn that the Cuban Revolution takes after Castro takes power, and start to fight him and take up arms against him. They're kicked out of the university. They go to Miami. They're actively fighting Castro, organizing opposition to him, and the CIA picks them up and starts funding them. So, and they get a lot of money from the CIA. By mid 1963, they're getting $50,000 a month, which in today's dollars is about $500,000 a month.
Wow.
So these are very active students. They're capable. They're totally dedicated to overthrowing Castro, and they're doing all sorts of oppositional political activities. Joanides is the guy who's in charge of them. He's meeting with their leaders, dispensing money, receiving intelligence reports throughout 1963. Well, in the summer of 1963, Lee Harvey Oswald comes to the attention of the Cuban Student Directorate's delegation in New Orleans. This is a group that has delegations in cities throughout North and South America. You know, the opposition to Castro was real. It was widespread among Cuban exiles, and the DRE was active in New Orleans. So when Oswald goes public in the summer of 1963 as a Castro supporter, a supporter of a pro-Castro group called the Fair Play for Cuba Committee, he comes to the attention of the DRE, and they publicize him, and they debate him on the radio, and they challenge him on the street, and they get into a fight with him, and he gets arrested, and he's seen on TV. So this CIA-funded group run by Joanides is the one who really develops or makes public this obscure character named Lee Harvey Oswald. So 3 months later, when Oswald is arrested for shooting and killing President Kennedy, the Cuban Student Directorate, they go to the press and they say, we know all about the guy who killed Kennedy. He's a Castro supporter. And that dominates the first day coverage. All of the information about the accused assassin and his Cuban efforts, all of it, I mean, every word of it was derived from Oswald's contacts and encounters with the CIA-funded Cuban Student Directorate in New Orleans. None of this was known. None of this was known to Oliver Stone. You know, it only emerged in the records that came out in the 1990s, thanks to the review board. So, and the review board didn't get very much because they didn't really know who he was. He was never interviewed by anybody. The name was totally new to all of us in the JFK research community. And so the review board releases a bunch of material, which actually isn't even public until after the review board shuts down. It was finally declassified in November 1998. And in there was a real bombshell, which was not only had Joanides been running those Cuban students who publicized Oswald before and after the assassination, but he had also been called out of retirement in 1978 to serve as the liaison to the House Select Committee on Assassinations. He was the representative of the Directorate of Operations, and he was supposed to help the HSCA find CIA documents, find CIA people, facilitate, support the congressional investigation. So I went to Bob Blakey and I said, Bob, did you remember this guy, Joanides? And he said, yeah, he was in the Office of Legal Counsel and he was helping us, you know, get stuff. And, you know, we had a lot of dealings with him. What about him? I said, well, did you know what he was doing in 1963? And Blakey said, well, we had an agreement with the CIA that we didn't want any people who were operational in 1963 to be working on the operation. I said, well, Bob, he was running the Cuban students who publicized Oswald. And Blakey was dumbfounded.
I would think so.
And he, and he realized he'd been duped. And Blakey then went on Frontline and he retracted a statement that he had made, which was after he'd finished his investigation. He said, the CIA cooperated with us, cooperated with our investigation.
Yeah.
And he retracted that and he said, no, they didn't. They lied to me. You know, I don't believe a word that they say. And so then I file a Freedom of Information Act request for the Joanides material. And, you know, the Freedom of Information Act is a weak law compared to the JFK Records Act. There was no right of action under the JFK Records Act, so I couldn't sue under that. My lawyer didn't see any other way to pursue the case. And so we went to the Freedom of Information Act. We got a lot of information, a lot more information about Joanides. We learned, for example, that he had a residence in New Orleans, which I didn't know before the litigation started. Well, that was where the contacts between the DRE and Oswald happened, was in New Orleans. So what was he doing there? got pretty much stonewalled on the records. And so, but we got a lot. We got a photograph of Joanides getting a medal. There was another thing we didn't know. After the guy his agents have contacts with Oswald, and after he stonewalls the HSCA about that knowledge, he gets a medal from the CIA. Well, why did he get the medal? The memo is classified. So Joe was a guy who was at the heart of the story in 1963. His agents had contact with Oswald and publicized him. And he's involved in the story in 1978 when he plays dumb to the House Select Committee and pretends like he didn't know anything about the DRE. And the HSCA investigators, Blakey told me, we asked the guy to his face who was running the DRE in 1963. And Joanides said, I'll get back to you. He himself was the answer to the question. That's how brazen the compromise of the House Select Committee assassination was. It was a bald-faced lie, face to face with the investigators. So of course these documents are of interest. We didn't get them, but we know now from the litigation that they have a big collection of documents about his secret operations in 1963 and 1978. We did not get those records last December. So the CIA is holding out on them, obviously relevant. Judge Tunheim, by the way, Judge Tunheim was also kind of pissed off about this because, you know, when they went to him and said, well, tell us who this guy Joanides was and, you know, what he was doing in 1963, the CIA coughed up 10 or 12 pages of documents. Tunheim said, if we had known who this guy was, we would have taken that whole thing in and we would have reviewed everything and we would have released very broadly. So Tunheim said in a letter to Biden in December, he said, you know, we were deceived on the Joanides question, and all of those records should be made public.
And so for a judge to say to the sitting president that he was deceived, that's pretty strong words.
Yeah.
Right. So you have Blakey, the head of one investigation, saying we were deceived, and you have Tunheim, the head of another investigation, saying we were deceived. So these are obviously important records. And this is, you know, this is another test case of, does the law have any reality? You know, because if it has any reality, we get these documents. If we don't get the Joanides file, the law is defunct. I mean, period. It's a very clear test case. It could not be clearer. And that's where we stand right now. And so, you know, we bring this up in the context of the lawsuit, which is not just about these records. These records are just one case study in the problem. We need a comprehensive solution to the JFK records problem. And when we do that, we will get information that is highly relevant to the causes of the assassination. There's no doubt about that.
Let's wrap up with that. So Larry, where I guess in the timeline of litigation here, where are you at? What's next, and really what is the end game for you guys? What are you trying to ultimately accomplish here? Because this is really important, and I know you guys are spearheading this effort. I think it's vitally important, and if you can educate you know, our listeners on again, you know, where you're at, where you're going with this.
So we named both the president individually and the National Archives. Now, the president, we're seeking injunctive relief. We're asking the president to comply with the statute. We're also asking National Archives to comply with the statute, asking the judge to issue an order. What does that mean? The National Archives, when the ARB went out of business in 2000, the National Archives published in the Federal Register a final rule where they moved the ARB's regulations, such as like defining what an assassination record is, into their set of regulations. And in doing so, the National Archives said that it was the successor in function to the ARB. What does successor in function mean? It means to me, at the minimum, what the ARB did, which was ask the agency to search for records, determine if they're assassination records, and determine if they can be declassified or not. The ARB had the power to overrule the agencies, and then only the president could overrule, could veto, in essence, the ARB's determination. So the National Archives has not followed up on any of the outstanding search requests that were in existence at the time the ARB went out of business. We now know there are more records that the ARB did not see. There are also missing records. The collection is a mess in terms of American citizens being able to search for records. So we're asking for this sort of relief. Now, for the National Archives, we're using the Administrative Procedures Act and the Federal Records Act. For the president is not an agency for purposes of the Administrative Procedures Act. So we found some pre-APA common law decisions that we're using as that basis to go after him. So we filed the complaint in October. It's on the Mary Ferrell website. It's Mary Ferrell, Ferrell. So if you just Google Mary Ferrell, .org, I think it is. The complaints there. We anticipate that the government is going to file a motion to dismiss.
Wow.
Shortly. And at that point, we think we have, I assume it's going to be partially on grounds of standing. As an environmental lawyer, I'm very familiar with standing arguments. So I think we're in good shape, but you never know. We're going to be facing 100 years of Department of Justice experience in standing. Yeah. So we have the initial conference with the judge, I think, is scheduled in May, perhaps. I forgot what precisely, but anyway, so we filed the complaint. They haven't filed an answer yet. We presume they're going to file a motion to dismiss before they file their answer. And if they do that, we'll be knowing in the next week or so if that's the case.
And I should say, Bill, I'm covering the lawsuit very closely in my JFK Facts subscription newsletter, jfkfacts.org, jfkfacts.substack.com. And so, when motions are filed, when we have a hearing, kind of the day-to-day stuff of the trial as it unfolds will be covered on JFK Facts. Substack, and the background material, the lawsuit itself, some of the press coverage, the history of the lawsuit is all available on maryferrell.org. So, we're just beginning to go now, and a lot is going to happen in the next few months around this, and we're going to get our day in court.
So, well, hopefully,
Yeah.
we're definitely going to get our day in court on the motion to dismiss. We're confident we'll survive that. The action was filed in the Northern District of California. We have a number of members of Mary Ferrell who live there who are researchers, and so that it's not in the district court in the DC district. It's in the Northern District of California. We'll see what happens.
The judge in the case, Richard Seaborg, is notable. He's the judge who threw out the the citizenship question on the census that President Trump and Secretary of Commerce Ross wanted to put in. And it was Judge Seaborg who said, who threw that out. So we're hopeful. He's a judge who's, has stood up to expressions of executive branch power and checked them and said, you don't have the authority to do that. So that's our situation going into court.
And just again, the big picture again is that the collection is not necessarily the universe of JFK records that are out there. And
that's a very important point.
We've developed, as part of our complaints, we've developed a list of documents that we believe are extant, that are not part of the collection, and that need to be searched for and need to be put into the collection so that the American people can see them.
Yeah.
Again, this is about compliance with the law. This is not about whether there was a conspiracy to kill the president. This is about complying with this very powerful law, which was enacted because the Freedom of Information Act, and it says that right there in the introductory clauses of the statute, that the way the National Security Executive Order was being interpreted and the way the Freedom of Information Act was being implemented, there was not resulting in release of documents. I mean, much of the records that we got in the 90s and the 80s were a result of individual lawsuits filed under the Freedom of Information Act. And that has a number of exceptions which have been exploited by the agencies. In fact, the FBI was using the law enforcement exception to try, and as far as I know, the FBI is not actively engaged in an investigation of the Kennedy assassination. As late as 2018, the FBI was holding back 6,000 records about the mafia.
Wow.
So, which raises all kinds of questions.
I'm sure different podcasts. Larry, Jeff, thank you so much for being on the Litigation Psychology podcast. It's a fascinating topic. Again, dear to my, I deeply, just personally appreciate all of your efforts. I will continue to follow your work. Definitely want to have you.
One more thing. I forgot. This is really important. In addition to the lawsuit, we are trying to get Congress to hold an oversight hearing. There are committees. The Oversight Committee in the House and the Homeland Security Committee in the Senate have continuing jurisdiction over the JFK Records Act. If you live in a state, if you have a representative that's sitting on the House Oversight Committee, or if you have a senator that's sitting on the Homeland Committee, committee, and you're interested in this topic, please write your congressperson or your senator to ask them to hold an oversight hearing on the failure of the executive branch to comply with the JFK Records Act. We have a lawsuit filed, but we want to get a public hearing on the statute. Hopefully, a public hearing would put pressure on the agencies and the president to comply with the act. So I just wanted to make sure that your listeners can play a role in this matter.
And your listeners should know, Judge Tunheim supports this too. He was disturbed by the sham release last December. And in his letter to Biden, where he urged maximum disclosure, afterwards, when he saw the results of it, he said, Congress needs to step in and hold hearings about why the JFK Records Act is not being enforced. So there is a congressional piece to this too. We're working with the press, we're working with the legal system, but we need to engage with the political system as well, because a solution ultimately has to come from the government itself.
And the other committee that potentially could help is the intelligence committees of both the House and the Senate. So again, your listeners, if they're interested in this topic, they should look up their congressperson, see if they sit on the intelligence or oversight committees in the House, and look up their senators and see if they sit on the Homeland Security or the intelligence committees in the Senate. And if they do, please write a letter asking them to hold an oversight hearing.
It begs a final question here. It took a feature film and Oliver Stone, really, in 1992 to get this thing, to get the public demanding. I mean, public, with pitchforks and torches, right? does it take another type of effort to now get this to the next level? I think Oliver Stone's film got this started, created enormous pressure, I think, on the government. And then also an enormous just kind of curiosity in the American public, and then a demanding American public. What can be done now to create a similar type of energy to keep this momentum going? Because obviously they're trying to kick this can down the road, kill the momentum. What can be done to get this back out? How can JFK become important to the public, just like it was in 1992, where it went to an act of Congress? How do we do that now?
I think we are trying to piggyback on the whole greater issue of classification. There's clearly overclassification in this country. What we're learning is, look, President Biden and President Trump did not pack their records by themselves and carry them physically to their homes, right? People did that for them. There is a problem with overclassification in this country.
Yep.
And if we can't get 60-year-old records declassified, how are we going to get records of the Trump and the Biden administration declassified? We have a problem in this country, and we want to use this current conversation in the country, use the JFK assassination as the poster child, right, for this problem. And so we're hoping that the momentum of that declassification or overclassification, that we can piggyback on that.
Outstanding, guys. Jeff, Larry, thank you so much. An incredible 2 hours. I know I got a lot out of this. I know our listeners will. Thank you so much to our audience. I hope you enjoyed that. Litigation Psychology Podcast brought to you by Courtroom Sciences. I'm Dr. Bill Kanasky. We'll see you next time.